Hello and welcome to this series of talks about bringing claims in the civil courts. These are aimed at helping litigants in person, and in this first series I want to talk about what you do before starting a claim, the very first considerations. My name is Declan O'Dempsey. I'm a barrister at Cloisters Chambers. The Royal Courts of Justice Citizens Advice Bureau has issued a very helpful series of leaflets concerning bringing your own case and going to court. I'm going to be referring to some of those as we go along. But in the very first of these, which I'd encourage you to have a look at, they ask several very important questions. What do you want to achieve? It's very important to have a clear idea of what your objectives are. Are your expectations realistic? Well, one way of testing that is to try and find out what the law says about your rights and obligations and the other side's rights or obligations. If you start out with a clear idea of what you want to do in order to solve your problem, whether you want to do it on your own or whether you want to have advice throughout or advice only at some stages, then you will have a better idea of whether or not you're making progress. At the start of a claim, it's always worth working out what your opponent's attitude towards solving the problem you've got is. Now sometimes it looks as if the other side are seeking to negotiate purely for tactical reasons, like trying to delay you. Don't jump to that conclusion immediately, but do have a think about whether you need advice on whether the other side are being tactical. And that may be an example of a point at which you might want to get some advice. What's your attitude towards negotiation? What's their attitude towards negotiation? Now instinctively you may have the attitude that you're not actually that interested in negotiating with somebody who you regard as wronged you. But the court procedures do put some pressure on litigants to try and get them to resolve their difficulties without resorting to the full court procedure. The Citizens Advice Bureau leaflet makes the very good point that going to court can sometimes be uncertain, unpredictable, expensive, surprisingly formal, risky, stressful, and I would add it can be very stressful. And they finally add that it's not a quick fix. It can take a long time. So it's worth bearing all of that in mind before you go in for litigation. You can get further advice from the sources displayed at the moment. So, before starting your claim, have a think about how strong your claim is. Are you in a position to evaluate that, or would it make sense to get advice? What are you going to need in order to evaluate it? Well, you're going to need to be able to access law. You're also going to need to be able to make sure that you can set out the facts really clearly and without emotion, and to be able to refer a court to the relevant documents. We'll come on to some of this later on. But one of the initial questions you have to deal with is which court you should start in, and in a later talk I'll be dealing with that. If you're going to involve legal representation, you should consider how you're going to pay for the case. Have a look at any insurance policies you've got. Some credit and debit cards carry with them legal insurance, and so it may be worth looking to see whether you can get advice and representation on that basis. Do have a clear idea, as I've said, of what action is needed. So what do you want the court to do if you're going to go to the court? Make an award of damages? Order the defendant to do something or stop doing something? Do you feel you're in a position to write out the details of your case? Again, with clarity. A good way of doing it is to set out a table consisting of column 1, the dates, column 2, the events, then column 3, evidence to support your version of the events. Now that could be a witness, and we'll come on to those in a minute, or it could be documentation that you've got, or indeed that the other side you think has got. So try and think how you're going to go about setting out the details of your case in a logical structure which pushes the court towards an inevitable conclusion, or which allows your advisor to advise you more quickly and therefore more cheaply for you. Are you in a position to write to the other side, setting out what you think your case is and warning them about forthcoming litigation? This is something that you will need to do. You can write those sorts of letters with a view to encouraging settlement rather than litigation. And the civil procedure rules do push you towards an early exposition of your case in detail, in a way that we'll see. The document that you're encouraged to write is known as a letter before claim, and a barrister instructed under the public access scheme or a solicitor can help you either by writing the letter or advising you of the best way that you can write the letter. Try to negotiate first. You can do it on a without prejudice basis. Without prejudice means that it's without prejudice to legal action, and it is a status which means that you can't introduce the document or the discussion that you have, which is held without prejudice, into the evidence that goes before the court. So what is said in a without prejudice conversation stays within the without prejudice conversation, as it were. Now, if you're writing to the other side and you want the document to attract this protected status, then it's sensible to write at the top of the document without prejudice. Then there can't really be any doubt that you intended what was involved in the letter to be an attempt at reaching an agreement in the case. There are some circumstances in which the without prejudice status will not apply, even if you've said it does, but if what you're doing is a genuine attempt to settle the claim, and that includes pointing out strengths and weaknesses in the other side's case, for example, then it's likely that that without prejudice status will remain intact, and the court that hears the final hearing or will never hear what happens within that without prejudice correspondence. So in other words, it gives you space within which you can communicate with the other side in a way that is not going to affect the view that the court takes of your case or of their case. Do have a think about alternative dispute resolution, because if you don't, then there may be cost implications for you. We'll come on to those later, but as I said, the court tries to encourage parties to reach an out-of-court settlement, and this is one of the ways it does it. ADR may also be useful if you want to preserve a relationship. It's much better than going to court. A public access scheme barrister can advise you on alternative dispute resolution. They can negotiate on your behalf or represent you, for example at a mediation if you want them to. They can also advise you on the merits of your claim before the claim starts. They can help you write the letter before claim, and all of this means that you may not need to go to court or issue proceedings. You may be able to end the claim by agreement, put a line under things, and get on with your life. However, if you have to go to court, or at least start to prepare to go to court, you'll need to have a look at the civil procedure rules. They're supposed to be written in an accessible style, but they're in numbered paragraphs. Some people find that quite difficult to deal with. They do use technical terms, but these are defined have a look at Rule 2.3 and in the glossary. Now, the civil procedure rules are actually divided up into what's known as parts, and there are practice directions for each part. Now, this is where the court has said how in practice it wants things to be run. So read them, they're very important. You'll need to establish whether your defendant is worth suing. Now again, the Royal Courts of Justice CAB has been very helpful in providing their second leaflet, which gives you a list of search sites that will help you to decide just this point. You're also going to have to consider whether the evidence you've got can prove, on the balance of probabilities, what you need to prove in relation to your claim. So for example, if you think you've got a breach of contract claim and you want to claim damages for it, you're going to have to be able to show that there was in fact an agreement whereby you promised to do something for the other side and they promised to do something for you. So for example, you offered to pay for services and they said they would provide the services. You're going to have to be able to show the breach, and you're going to have to be able to show the loss that resulted from the breach. So you're going to have to be able to show each of those bits on the basis of facts, and you're going to have to persuade the court that your version of the facts is more likely than not. So think at an early stage whether you need witnesses, who might give evidence for you, whether they actually will give evidence for you. Now, if you've got somebody who might be prepared to give evidence for you, try and get their recollection down onto paper as soon as you can, before memories start to fade of the events which they can help to witness. It also means that they've committed themselves to a statement of events, and that may well mean that when it comes later on to writing a witness statement, they feel that they've already said what happened and feel more inclined to help you with the witness statement. And then finally, when it comes to the hearing, because they've done a witness statement and they've been saying the same thing for a long time, they may be more willing to actually attend court. But don't be surprised if witnesses get cold feet, and they may get cold feet at an early stage. So that's why I ask, will the people that you're hoping you can rely on actually give evidence for you? And there are some ideas as to how you might get a better picture of their willingness, but also the facts they're going to give you at an early stage. Of course, you can also rely on documents. So what documents have you got to prove what you need to prove? Consider the damages that you may get, because if the claim's not worth very much and you're going to have to put a huge amount of effort into securing the result you want, then you may think that it's better to try and reach an early agreement with the other side and not to pursue litigation itself. So let's think about the tests that the court apply for various types of claim. In a contract claim, you get the loss which flows naturally from the breach, or loss which was in the reasonable contemplation of you and the other side of the contract at the time when the contract was made. In negligence claims, you get direct loss and loss which is reasonably foreseeable as a consequence of the negligence. Now, you must also always take reasonable steps to lessen or mitigate the losses. In a debt case, which is a type of contract claim for a liquidated or specified sum, you don't have to do that. But notice some things about damages, and these are incredibly important principles which sometimes get overlooked when people are hot and bothered about a case. It's not what you think should be recovered that matters. So in other words, you may feel very strongly that you should get very large damages. Apply the tests which I've just gone through with you, and ask yourself, by taking a step back, whether an impartial observer would say using the tests that we've talked about, that this is the sort of loss that you should get in the type of case that you're bringing. So, would an impartial person say that the loss you're talking about naturally flows from the breach of contract? Or would they say that it was within the contemplation of the parties at the time of the contract being reached or finalised? There are different types of loss. There are ascertained losses like past wages or lost profit in the past. These are known as liquidated or special damages, and that's used in contradistinction to general damages, which are not specified sums but which are judged. Now these will include things like pain, suffering and loss of amenities of life in a personal injury claim, but it may also include things like future specific losses such as loss of wages and so forth. Here are some points about interest. You can claim interest in contract cases from the date that the cause of action arose, or the cause of the claim arose, to the judgment, or, if it occurs before, the date of payment. And you either get it at the rate in the contract or at the court's discretionary rate. Different rules apply in debt cases, but in non-personal injury negligence claims, interest is discretionary. Not so in personal injury claims. In personal injury claims, the court has to award interest unless a special reason is given, and if the judgment is for more than £200. There's no interest on future loss of earnings, and those general damages, pain, suffering and loss of amenity damages, attract 2% interest from the service of the claim form to the date of trial. Those special damages get half the court's special account average rate from the accident to the trial.